Good evening, everyone. Good evening, everyone. Madam,
Right, sir? Sir, why don't you come
good evening,
tomorrow
everyone.
to second part court? We take the forms and all, and even that one
We will-
also get it.
I'll speak to you once your classes are over.
Right, sir. Yes. Good evening to all of you. The Limitation Act, yesterday I was giving you the introduction. Today we just start the subject in the right perspective. Today, as far as possible, I try to finish the sections and articles. We'll discuss it tomorrow. And no interaction today, please, because this Limitation Act we have taken up. Let us see it's finished, and after that we'll have the interactions. Here, the Limitation Act is, yes.
Bit loud, sir, that's it.
Yeah, Section 3 of the Limitation Act, actually, first and foremost, is the Limitation Act applies only to applications and execution petitions alone. It does not apply to and appeals, rather. It does not apply to suits. This is the first and foremost principle you must bear it in mind. Here, Section 3 of the first 1 and 2 of the second section contains the definitions, which is not new to you. Section 3 says suits or appeal filed beyond limitation shall be dismissed, irrespective of the grounds raised. So, any suit or any appeal which is filed beyond limitation that is prescribed under the Limitation Act is shall be dismissed, and irrespective of the grounds raised. So, the question is, time and tide wait for no man, and whenever you want a remedy to be enforced through court of law, you have to bring it within time. Sir, you should file it with time. So it says any suit or appeal which is filed beyond the period of limitation shall be dismissed, irrespective of the grounds raised. So the question is, limitation applies as a bar to any suit or appeal which is not filed within time. Then Section 4 is expiry of the prescribed period when court is closed. Normally, we are having the summer vacation, we are having the Dasara vacation, or we are having the Shankranti vacation. Suppose the court is closed, then the next reopening day will be the date within which you must file the limitation suit. This is what Section 4 says. Section 5, I discussed it in detail yesterday. It applies to extension of time in filing application or execution. Here, as far as Section 5 is concerned, I told you yesterday itself, it's supposed to be the Zinda Talisman. As far as every delay petition is concerned, it applies only to application and execution proceedings. I've discussed it in detail. I don't want to repeat it again. Then Section 6 deals with persons suffering from legal disability. Section 11 of the Section 11. Section 11 of the Contracts Act says any contract with a minor, a person of unsound mind, idiot, or a person disqualified under any law for the time being enforced, they are all persons suffering from legal disability. But as far as Section 6, also I discussed yesterday that the period of limitation starts from the day when the cessation of the disability ceases. Suppose the minor attains the age of majority, the period of limitation starts from the date when he attains majority and not on the day when he is still a minor. Then Section 7 deals with disability of one or several persons. Concurrence of others are taken. Here, suppose, let us say there are 4 or 5 people who are entitled to sue or entitled to be sued. Then in that case, if any liability arises, if all of them agree that even without that person suffering from disability, the matter can be filed, matter can be agitated, then in that case, the question is Section 7 operates as an exception as far as legal disability is concerned. Then we go to Section 8, that is special exceptions, that is enforcing preemption rights 3 years from the cessation of disability. Preemption, what do you mean by preemption? Preemption means a preferential right of a co-sharer to participate in the proceedings or to participate in the sale or to acquire a particular right. And if that person is suffering from legal disability or then in that particular case, the right of preemption is 3 years from the date of cessation of disability. Suppose the minor is aged, let us say hypothetical case, he is aged 5 years. Once he finishes the 13 years period, he becomes a major, and the period of limitation stands suspended during his disability. Then section 9 is what is called continuous running of time. It is said in English, time and tide wait for no man, that wherever time has begun to run, the subsequent disability or inability to institute a suit or make an application, stop it. Here, as far as this, suppose the time has already started and it is also said, and time has begun, and no subsequent disability or inability to institute a suit or make an application stops it. The question is, suppose the disability comes later, inability comes later, then the suit has to be instituted within the time, and any subsequent disability or inability cannot stop the suit, and it says the time runs continuously. Then section 10 is suits against trustees and their representatives. Here, as far as suits against trustees and representatives are concerned, once the period of limitation starts running from the date when the property gets vested in the trustees or their representatives. Here, then section 11 deals with what is called suits outside the territories of India, to which here as far as, please remember, Jammu and Kashmir till section 370, article 370 was abolished. They said any law that is applicable to all of us will not apply as far as the territory of Jammu and Kashmir is concerned. Then section 12, exclusion of time in legal proceedings. These are all which I've completed. That's the reason I'm running through, sir. Exclusion of time in legal proceedings. Here, as far as the it shall be reckoned. That is, it says, in computing the period of limitation, the day from which such period is to be reckoned shall be reckoned. That means, as far as exclusion of time is concerned, suppose, let us say, you take about 20 days. Suppose the judgment is passed on 10th June and you obtain the copies only on 30th June. The 20 days period which you spend for the purpose of obtaining copies shall be excluded for the purpose of limitation. Then section 13 is exclusion of time where that is supposed to leave to sue or appeal as a pauper is applied for. In summary suits under Order 37, you do not have a right of defending the suit as a matter of right. You will have to file the application to sue, application to defend the suit within 10 days from service of notice, service of judgment, and then alone the question of time is taken, and that period which is taken to dispose of the matter is excluded for the purpose of limitation. And suppose you apply for suing this, filing the suit as a pauper, the period for which the pauper inquiry goes on is excluded. That's what section 13 says. Then suppose, let us say, please remember, all of us commit the same mistake. That is the reason we'll have to go through the jurisdiction part of it before filing a suit. Suppose instead of filing a suit in the senior court, you file a suit in the junior court, which has no jurisdiction. Then in that case, the court returns your suit with the objections, saying that this court has no jurisdiction. File the suit before the proper court of proper jurisdiction. In that case, the court grants you 14 days time to comply with the objections and file it before the superior court. But you have to take return of it and file the suit before the proper court. And the day when you file in an inferior court which has no jurisdiction, the question is, it will be taken as if the suit is filed within time, provided you represent it or resubmit it before the competent court. That is what section 14 deals with. Then section 15 is exclusion of time in certain other cases. Suppose, let us say, the other side obtains an injunction, or the suit is stayed, or any appeal proceeding is pending, then that period for which which is taken during for the pendency of those remedies will be excluded for the purpose of limitation. Then section 17 deals with fraud. Section 17 says, as far as fraud is concerned, section 16 says, effect of death on or before the accrued right to sue. That if the period shall be computed from the time where there is a legal representative deceased capable of instituting such a suit or making such an application. Suppose a person dies before filing a suit. His LR or transferees in interest or assignees can bring the suit as soon as it is known that the deceased had a legal representative. The period of reckoning will be the date when the existence of the legal representative is known. The legal representative also can initiate action under Section 16 of the Limitation Act. Then we come to the sections which we have not covered yesterday. That Section 17, effect of fraud or mistake. As far as fraud is concerned, mistake is concerned, the period of limitation does not start from the day when the fraud or mistake is committed, but the day on which the fraud or mistake is detected. And as far as fraud and mistake is concerned, it has to be clearly pleaded in your pleading, in your plea. And as far as fraud is concerned, there is no limitation at all. As far as mistake is concerned, there is no limitation at all. And the limitation period starts from the date when you have discovered the fraud or when you have discovered the mistake. That's what Section 18 deals with. Then 17 deals with. Then Section 18 is acknowledgement in writing. This also I discussed it yesterday, but in a lighter way. Here, acknowledgement means, suppose let us say there's a promissory note. You know, the life of a promissory note is only 3 years, but on the reverse of it, the debtor pays a particular sum of money and signs on it, and he also signs on the date when the payment is made, and the creditor also acknowledges it by putting his signature. Every endorsement made on the reverse of a promissory note or a negotiable instrument extends the period of limitation, and in law it is called acknowledgement. I also discussed what the bankers do. They take 3 documents. One is called AOD, COV, and revival letter. AOD means acknowledgement of debt. The debtor says, yes, sir, I am indebted to you to the extent mentioned in the document. Then confirmation of balances. It is the duty of the bank to take confirmation of the balance standing into the account every quarter, and they take the signature of the party on the confirmation of balances also. And they also take a revival letter saying that the documents executed at the time of sanction of the loan stands good and no further documentation is required. All these things amount to what is called acknowledgement. Acknowledgement as laid down in Section 18. Then next one is effect of payment on account of debt or of interest on legacy. Suppose let us say some fixed deposit is left in you or stands in your name. Whatever interest is paid to you or whatever payment you pay in respect of the debt will be properly accounted for, and it amount every payment made on a particular day at a particular time amounts to acknowledgement, amounts to admission of the liability. Then Section 21 deals with effect of substituting or adding new plaintiff or defendant. As far as a new plaintiff or new defendant is concerned, when they are added as parties to the suit, from the day when they are added, the period of limitation starts running. It will be taken as if they were impleaded earlier itself. Then we go to Section 22, continuous breach breaches and torts. Suppose let us say every day the breach has occurred, every day your rights are being violated, every day there has been a violation, and every day when the violation takes place, every day gives you the period of limitation as far as 22 is concerned. Then 23, suits for compensation for acts and actions without special damage. Suppose let us say for libel or for slander, you are entitled for damages. Without asking for special damages, the court can grant you damages. That is what Section 23 says. Then 24 says computation of time mentioned in the instrument. Suppose, please remember, all times are reckoned by the Gregorian calendar, that is your English calendar. Then the question is, here it is said it will be reckoned from the day which is mentioned in the calendar, and that is the period for enforcing an instrument. That is what 24 deals with. Then 25 deals with acquisition of interest by possession. Please remember, in law we have got 2 types of heritages. One is called dominant heritage and another is called servient heritage. Dominant heritage means proprietary rights, titular rights, which are transferred as far as the instrument is concerned. But along with that, you have a word called together with all easements and appurtenances attached thereto. That means, suppose your vendor is enjoying the property or enjoying a servient heritage, right, like right of light, air, sanitation, ventilation, ingress and egress, or worshipping at a particular temple, or for irrigation waters to cultivate his land, or a right to pass through the neighbor's land through the bund, then all these rights which you are which your vendor had automatically pass on to you by transfer of the dominant heritage. And these rights which you enjoy, your vendor also enjoyed for 20 long years uninterruptedly, continuously, it gets automatically passed on to you as a purchaser. That is why it is said easements. Easements is a right over your neighbor's property for a continuous usage of 20 years, and also the what is called these rights and appurtenances. Appurtenances means doors, windows, pipelines, electrical lines, and also the motor and the borewell, which is part of the property. All these things pass on to you immediately on the transfer of the property, and all rights were enjoyed by your land, by your vendor, they automatically get passed on to you. That is exceeding to for granting the enjoyment of easement during the continuation of any interest shall be explained computes. Then 27 is extinguishment. Extinguishment means suppose it is given for a limited duration of time for a period of 3 years, let us say. Beyond that, you cannot enjoy. And then it is said the easement gets extinguished. Then the limited suits can be brought under this limitation act. If the suppose let us say before the commencement of this act, suppose a shorter period is mentioned to institute a suit, then under the limitation act a longer period is given, then the period will be made good, and under the limitation act only the limitation starts. Then does not affect any suit here. That is suits filed before the act came into force. Such suits are not affected by the passing of the limitation act. So this is as far as the substantive law is concerned. Substantive law is concerned under the limitation act. So limitation act consists of 32 sections, and these sections we have discussed it in detail, and much of importance need not be given to it. But as far as the practitioner is concerned, we are concerned with the articles which has practical operation as far as courts are concerned. These articles are from Article 1 to Article 137. Article 1 consists of what it's called current, open, and mutual account. Please remember, if you want to get loan facilities from the bank, you have to necessarily open a current account. And current account, please bear it in mind, it does not carry any interest. It is only a current account, means current account is open, and all the transactions which you have in respect of the transactions between you and your outsider, the transactions should be routed through the bank, and the amounts realized through sale will have to be deposited in the bank where the loan facilities are granted. It is also called an open account because it is not closed. Not closed means it is left open. There are mutual credits and debits into the in respect of the account, and every credit and every debit extends the period of limitation as far as a suit is concerned, and that is the reason 3 years period is granted as far as bringing a suit uh, to the primary documents. But here, suppose let us say mutual debits and credits are there, and it is an open account, and then it has not been closed. Then in that case, it is 3 years from the date when the last date or last credit or last debit is into the account. Here, one thing you must remember when you plead in the suit, when especially when you write in the plaint, you must make it very, very clear that the suit account is in the nature of a current, open, and mutual account, and the suit is within time as stipulated in Article 1 of the Limitation Act. That is Article 1. Is it clear to you, please? This also I discussed it yesterday. Now coming to today, Article 2 deals with what is called against a factor for an account when the account is during the continuance of the agency demanded and refused, or where to such demand is made when the agency terminates. Here, agency is also not given for an unlimited duration of time. Suppose, let us say, the agent owes you something as you are the principal. Then, within what time you must ask for the accounts, sir, or ask for the accounts to be submitted and a claim to be made against the factor or what is called your agent. So long as the agency business survives and once it is terminated, then in that case, within 3 years, whatever money you have to receive as a principal, you can recover it against your agent. Then third one is when the principal against his agent for movable property received by the latter and not accounted for. Suppose let us say the agent receives the money, thank you. Excuse me, please. Sir, anyhow, I brought them. Anasa, Narma, exchanges అయిపోయింది. మీరు దయచేసి ఆయనతో ఏ కయ్యాలు పెట్టుకోకండి మీరు చెప్పకుండా ఎక్కడికి వెళ్ళమాకండి. నాకు విశ్వనాథ్ గారు క్లయింట్ గారు నాకు బ్రదర్ లాగానే ఆల్మోస్ట్. Then you meet me tomorrow morning. Carry. So, sorry, please. Here, as far as the third article is concerned, by principle against his agent for immovable property received by the latter and not accounted for. Sometimes what happens is these agents who act for and on behalf of the principal receive some movable property from third parties which does not belong to him, but it belongs to the principal. He does not account for it or does not maintain proper accounts for it or does not enter it in the register that these properties are received. That is, movable properties are received. Then in that case, the movable properties are in the custody of the agent. Then the principal has got a right of recovering that movable property within what time, sir? If the agency terminates, within 3 years from that day, he can ask for the recovery of movable property. That is Article 3. Then Article 4 is other suits by principals against agents for neglect or misconduct. Suppose, let us say, the agent misappropriates the money, embezzles the money, or commits a breach of trust which is reposed on him by the principal. Then in that case, the principal has got a right of recovering that money which has been misappropriated, misused, and he can ask for what is called to be for that amount to be made good. And this normally, though it is not strictly available in the State Bank of Hyderabad, there's a policy called Fidelity Insurance, FIDELITY. Fidelity means you assure the faithfulness of your employee. And for that purpose, especially when you're appointed as a cash officer, my funds come into your hands. Suppose the cashier misappropriates the money, commits a breach of trust, then the bank, as a bank, is immediately writes to the insurance company, and the insurance company pays the amount which has been mismanaged or which has been embezzled. But later, what the banker does is the banker as well as the insurance company bring a suit for what is called subrogation against the person who has embezzled the money or his fidelity which has been insured, and then recover the money, and that money goes to the insurance company. And that suit has to be brought within a period of 3 years. Then, sir, next is 5. Article 5 is for an account or a share of the profits of a dissolved partnership. Suppose, let us say, what are the incidents of a partnership, sir? How is partnership defined? Where two or more persons come together, pool up their respective investments, and build up an edifice called a business. Build up an edifice called the business on which the superstructure rests, and with the ultimate object of making profits and sharing the profits amongst themselves. This is how a partnership is defined. And it's also said every partner is supposed to be an agent of the other, every partner is a trustee of the other, every partner is a manager of the other, and the liability of a partner is joint and several. Suppose, let us say, the rights of an agreed partner is he can ask for accounts and he can also ask for dissolution, or he can ask for accounts without dissolution or dissolution coupled with accounts. For that period, once the dissolution takes place, accounts are settled, and if any misappropriation is there, then you can file a suit within a period of 3 years against the erring partner or the partner who has embezzled money. Then next one is seamen's wages. That is during which the wages are earned. So seamen's wages is the person who is a captain of the crew, the person is a host of the crew, the person who is a servant of the crew. Then as far as his wages are concerned, that once the voyage ends, he has to be paid, and that suit can be brought within a period of 3 years. Then for wages in case of any other person, then when the wages accrue, you suppose, let us say, every month you are entitled for wages, or every week you are entitled for wages, or every fortnightly you are entitled for wages, within 3 years you can bring a suit to enforce your claim. Then Article 8, deals with what is called price of food or drink sold by the keeper of a hotel, tavern, or lodging house. That is, as far as the uh, price of food or anything concerned, drinks sold. Please remember now, I think perhaps this is not apply because if you go to a club also and if you want to have a drink, you have to pay the money and then alone the drink is supplied to you. But any food which you have, you can have an account with the club and every month when the bill is charged, you must pay the bill. And for recovery of that, it is 3 years from the date when the food or drink is served. And every month you get the bill whether you like it or not. And even if you don't pay, within 3 years, always the claim can be made against you. Then next one is for the price of lodging, where the price becomes payable. Please remember these things are all obsolete now. Please remember without paying the money, without they take what you call advance also from you. And let us say when you vacate, and now I think GST also is levied. And then the question is when you vacate, you will have to pay whatever arrears are due by you. And within 3 years, if the arrears are not paid, within 3 years, the person who is running the lodge can recover that money. That is Section 9, Article 9, sorry. Then Article 10 is against the carrier for compensation for losing or injuring goods. Suppose the goods are lost in transit, or suppose the goods are damaged, or the goods become deteriorated, or there is negligence on the part of the carrier in carrying the goods from one place to another. For that, 3 years period is given where you can file a suit against the carrier for negligence, etc. Then 10th one is against the credit against the carrier. Then 11th one is against the carrier for compensation for non-delivery or delay in delivering goods. Suppose let us say for the person who consigns the goods or entrusts it to the carrier, in case there is damage to the goods, in case there is a delay in handing over the goods, or there is not, or the goods are not delivered at all, then a suit can be brought by the consignor against the carrier within 3 years. Then 12th article is for the hire of animals, vehicles, boats, or household furniture. 3 years. So I think nowadays, boats are also hired if you want to go on a voyage or if you want to go on a pleasure trip. But please remember, all these things may be obsolete now. Why? Because without purchasing the ticket, without paying the money, no person will allow you to use his boat. No person will allow you to use what is called the household furniture. In hire purchase, normally every month you are supposed to pay the installments regularly, and for that reason they take the PDCs, and within 3 years period they can always enforce their claim. Then Article 13 deals with balance of money advanced in payment of goods to be delivered. That is for the balance of money advanced in payment of goods to be delivered. Now you got Amazon Pay and all this, Flipkart and all. They say you need not pay cash immediately, but you can pay cash on delivery. And delivery, suppose you don't pay, then whatever value of the goods are there, you will have to pay, and that right can be enforced within a period of 3 years. Then Article 15 deals with price of goods sold and delivered to be paid after the expiry of the fixed period of credit. Normally, sometimes what happens is credit is also given to you. You can pay it within 90 days, or you go to a grocery shop, you have a regular account with them, then you don't pay the money every month or every 2 months, then the grocery shop person can bring a suit against you within a period of 3 years for the unpaid price. Then price of goods sold and delivered to the paid or by a bill of exchange, no such bill being given. Then 3 years when the period of the proposed bill elapses. Suppose the bill is given, suppose credit is given to you, and within 3 years, you have to pay it within a time span. And suppose it is not paid, then within 3 years a suit can be instituted. Then 17 is price of trees of growing crops sold by the plaintiff to the defendant where no fixed period of credit is agreed upon. Then price of trees of growing crops sold by the plaintiff to the defendant where no period is fixed. Suppose, let us say, suppose crops are grown on the trees, or fruits are grown on the trees, no time limit is fixed for payment. Then in that case, if payment is not made, then the 3 years you can bring a suit. Then for the price of work done by the plaintiff or the defendant at his request, where no time has been fixed. That is, suppose let us say you call your carpenter and ask him to prepare some furniture for you. You bring the material. Then for his labor cost, you have to pay. If you don't pay, the carpenter can charge you and he can bring a suit against you for the non-payment within 3 years. Then 19 is for money payable for money lent. Then as far as money transactions are concerned, if you execute a promise or note, amount has been given to you as a money as a hand loan, then you have to pay it within 3 years. If you don't pay, a suit can be brought against you for enforcement of the debt. Then 20 deals with what is called like suit when the lender has given check for the money. Suppose let us say when the check is paid. Suppose let us say the lender has given, that is where the lender has given a check for the money. Like and when the lender has given money for the given check for the money. Suppose you give a check and let us say you don't pay, then the amount mentioned in the check has to be paid and a suit can be brought within a period of 3 years. Suppose, let us say, money lent under an agreement that it shall be payable on demand, your promise or note, etc., on demand or order, the period of limitation under Article 21 is 3 years. Then 22 is money deposited under an agreement that it shall be payable on demand, including money of a customer in the hands of his banker, so payable. Suppose your fixed deposit is there and it has not been paid, or it is an endowment policy, or it's a policy payable after the expiry of 1 year, or it's a recurring deposit which the banker has not paid to you. Within 3 years, you can institute a suit against the banker and claim that money. That is Article 22. Then 23 is to the plaintiff for money paid for the defendant. That is for money payable to the plaintiff for money paid for the defendant. That is when the money is paid. Suppose let us say the a good person pays the money on behalf of a person who has borrowed money from the creditor. Then that money which has been lent or which has been paid to satisfy a debt, the person who has lent that money or the person who has paid that money on behalf of another person can file a suit within 3 years to claim that amount. Then we go to Article 24, that is money payable for money. Then 25 deals with for money payable for interest upon money due from the defendant to the plaintiff. Suppose any interest is charged under the loan, the question of interest has not been paid, then 3 years' time is given to recover that interest amount which is due by the debtor. Then 26 deals with payable to the plaintiff for money found to be due from the defendant to the plaintiff on account stated between them. Suppose accounts are maintained. I told you a Marwadi who maintains a kata or who maintains a paddu as it is called in your Marwadi language, that money which is found due and payable, if you do not pay, a period of 3 years is given to recover that money. Then 27 is for compensation for breach of a promise to do anything at a specified time or upon the happening of a specified contingency. Suppose, let us say, compensation for breach of a promise to do anything. And then suppose, let us say, the promise has to be performed within a period of 20 days. And suppose the promise is not performed within that 20 days period, then the question of compensation can be claimed by the person who has suffered a damage, and that suit can be filed within a period of 3 years. Then 28 deals with a single bond where a day is specified for payment. Suppose, let us say, a single document is that if you go to most of the villages, they take it on a bond. They take it on a 10 rupee stamp paper or 20 rupee stamp paper or 50 rupee stamp paper, and it is in the form of a bond. Then in that case, within 3 years, you can always file a suit and then recover that money. Then 29 deals, then 30 deals with on a bond subject to a condition. Suppose a condition is given that the period is fixed and within which time the payment has to be made. The payment has to be made within that time. If it is not made within that time, a period of 3 years is given as far as the Limitation Act is concerned. So now we reserve our, that is, we have finished up to Article 30. We will reserve our lecture from 31 to 137 tomorrow. Any questions, please? Any questions? Please raise your hand and ask a question. I'm here to deal with that. Yes.
I hope so. No questions are for today. Well, we call for a day. We conclude it. Thank you much.
Madam, తిన్నారమ్మా?